is connected to our meeting through telephone.
Okay, that's fine.
I am here. Can you hear me?
Yes.
Yes,
Who is
this is Victor Apolacta. Good morning.
Good morning. Ms. Naranjo Lopez, are you on? Ms. Lopez?
Yes, I'm on.
Good. Good morning. I don't see you. Are you by phone as well?
Can you see me now?
No, ma'am.
Oh, wait, let me change the name because we use our,
There you are. I can see you
yeah,
now.
I'm gonna rename it though.
Go ahead. We'll start in a moment.
Okay.
Mr. Chavez, do you know what Lorena's last name is? Lorna?
That
I'm
would
here.
be,
The last name is Patton, Patten, hyphen Quintana, Quintana.
Thank you.
Thank you.
good morning, Ms. Quintana.
Good morning. How are you?
I'm well, thank you. How are you?
I'm well, thank you.
Okay. When Mr. Moya gives us the go-ahead, when we are live streaming, that we will begin it on the record, okay?
Mr. Chavez, we are live and you are good to go.
Okay, good. Let's get started then. Good morning, folks. We are on the record. I'm Stephen Chavez, the city's land use hearing officer. Today's date is October 2nd, 2020. This is a quasi-judicial hearing, an appeal from the zoning hearing examiner, the ZHE. This is numbered AC 20-9. As you all know, we are under public health orders for the pandemic. Because this is a time-sensitive appeal, this hearing is being conducted remotely via video and audio conferencing. Now, to prevent background noise, participants will be muted automatically when they're not speaking. If you do need to speak or raise an objection, just unmute your audio on the Zoom program screen, okay? Now, please turn off your cameras if you can. This will help prevent lag time on your end. This hearing is open to the general public to watch on the city's YouTube channel as it is occurring. This hearing is also being recorded by a certified court reporter, and Rebecca Fella is our court reporter today. I understand that the Santa Barbara Martinez Town Neighborhood Association, excuse me, has entered an appearance as a party opponent. I've accepted that. And I believe the neighborhood association is being represented by Ms. Naranjo Lopez. Is that correct, Ms. Lopez?
Yes.
Okay.
Yes.
Now, beginning with the appellants,
Okay.
please make your appearances for the record. Ms. Garcia?
Thank you. Thank you, Mr. Chavez. My name is Juanita Garcia, and I'm with JAG Planning and Zoning.
Okay, and Mr. Victor Apodaca, who is the applicant, is on the line as well. Ms. Garcia and Mr. Apodaca, please raise your right hands. I'd like to swear both of you in. Mr. Apodaca, is your right hand raised?
It is.
Thank you. Do you affirm to tell the truth and only the truth under penalty of perjury?
I do.
I do.
Thank you so much. And Ms. Naranjo Lopez, please state your full name for our record.
Loretta Naranjo Lopez.
Please raise your right hand. Do you affirm to tell the truth, the whole truth, and only the truth under penalty of perjury?
I do.
Thank you. And just for our record, you have entered your appearance on behalf of the Santa Barbara Martinez Town Neighborhood Association. Is that correct?
That's correct.
Okay. I note that there was an issue. You wrongfully believed apparently that you have a as of right to, that is a automatic right to be a party in this appeal. That is not the case. Under our rules, neighborhood associations aren't automatically parties. I have no problem with making neighborhood associations parties if they so choose, but they do have to enter an appearance so that they can get notice. So in a previous hearing,
It's that
That is
number.
in a hearing that's being appealed, what you need to do in the future is make sure you note with, for example, the ZHE, in this case, you note with the ZHE that you want notice of the appeal if there is going to be an appeal, and certainly it'll follow down the road, but you don't get automatic notice because that would violate, it wouldn't necessarily violate the IDO, but it's not contemplated in the IDO. But no problem. We got it all worked out. I'm glad you're here today. So are there any other preliminary or procedural matters or questions before we get to the merits of this appeal, beginning with the appellant? Ms. Garcia.
No, we do not have anything to add or any questions.
Okay. Before we go further, Ms. Patton Quintana, are you going to testify in this hearing this morning?
Not unless it's needed.
Okay. I don't anticipate needing you. And certainly the other parties can call you as a witness if they so choose. But because this is a record appeal, certainly I don't think it's necessary, but you're welcome to stay on. Ms. Lopez, Naranjo Lopez, are there any questions or procedural matters that you would like to get on the record before we go to the merits?
No, you
Okay,
clarified everything. Thank you.
Thank you, ma'am. Let's get started, folks. Ms. Garcia, you have the floor.
Thank you, Mr. Chavez. So as you mentioned earlier, we are here to appeal the denial of a conditional use application. The appellant is proposing to construct a 3,000 square foot self-storage building to store construction material that is currently used for the applicant's construction business. The applicant has owned and operated the current business on the site for over 5 years. JFQ Construction provides general contracting services and mostly works on state of New Mexico Highway Department projects throughout New Mexico. The subject site of 1718 Broadway is located on Broadway between I-40 and Lomas Boulevard. The site was originally developed as residential with 2 single-family dwelling units. The applicant intends to demolish the back dwelling unit in order to construct the self-storage building, and the second dwelling unit has been converted to office space. The property owner was notified of violations on the site in relation to the construction equipment and material on the site, and the proposed self-storage building is intended to bring the property into compliance with the regulations of the IDO. So we respectfully believe the zoning hearing examiner erred in denying the request when applying the requirements of the IDO. The zoning hearing examiner indicates the reason for denial is because the applicant did not reference any specific policies in the comprehensive plan. It is factual that the application did not quote any specific policy from the comprehensive plan, but there was an attempt to adjust the criterion. The applicant provided a general statement in regards to meeting the comprehensive plan by proposing an application for a use that is allowable within the site zone category that will be developed in a manner that will address abutting residential uses. The applicant did not include the reference of any specific policy within the comprehensive plan because it was unclear that one needed to be provided given the novelty of the process created within the IDO for conditional use applications because of the language within the IDO regarding the criterion itself. So the response to this criterion did not address any specific policy, but it did address how the application would generally meet the comprehensive plan by proposing a use that is expected to occur within this zone category, and if approved, would be developed in a manner that will be consistent with the comprehensive plan. The policies supporting these arguments can be found within policy 5.122, directing growth of the comprehensive plan, identifies places in the city where development is expected and encouraged, in development areas identified as areas of consistency. As mentioned, the subject site, as mentioned in the case file, the subject site is located in an area of consistency, and development that does happen should be designed carefully to reinforce the character, scale, and intensity of the surrounding neighborhoods or non-residential development. The response to this criterion also indicated that the site would be developed in a manner that would be consistent with standards of the IDO, specifically related to off-street parking, building setbacks, building height limitations, landscaping requirements that are intended to protect nearby existing development as identified in policy 5.63, area of consistency of the comprehensive plan. The IDO was recently adopted by the city of Albuquerque and took many years of analysis and review to determine the appropriate uses, permissive and conditional, within each of the zone categories. Since all the uses identified within a zone category by the recently adopted IDO were carefully and methodically listed in consideration of the comprehensive plan, the expectation is that all uses allowed within a particular zone should meet the goals and policies of the comprehensive plan. Furthermore, IDO also contains development standards such as setbacks, off-street parking, landscaping requirements to help guide development in a manner that is consistent with the comprehensive plan. In addition to the development standards, the IDO has criteria for a conditional use application if the application meets the criteria. Implies that the conditional use will meet the policies and the goals of the comprehensive plan. Further review, this type of request, conditional use for storage, self-storage, contains another set of criteria that were addressed separately. However, the ZHE did not address or provide analysis regarding all the remaining criteria, and it's unclear if the application would have met the remaining criteria. On page 17 of the comprehensive plan is described as the main policy document used to guide discretionary decisions about changes to zoning and the adoption of new plan. The plan relies on—
Ms. Garcia, I apologize. Did you say page 17 or
Yes.
policy 1.7?
No, on page 17.
Okay, page 17 or
On page 17 of the comprehensive plan.
got it. The comprehensive plan. Okay, I apologize. Proceed.
No, you're fine. So the plan relies on coordinated zoning standards and capital improvement programs to give teeth to the shoulds and that it sets out. Language in the comprehensive plan identifies that the goals and policies are to be used in zone changes, new policies, plans, and capital improvement plans and actions priorities, but does not specifically reference a conditional use. Given this language, applications similar to a conditional use should rely heavily on the criteria beyond criteria number 1 and regulations within the IDO to determine if a conditional use can be approved, which will arguably meet the goals and policies of the comprehensive plan. So the zoning hearing examiner did not receive a recommendation from staff as outlined in the IDO. The procedural process for a conditional use application as identified in the IDO indicates that staff shall review the application and forward a recommendation to the ZHE pursuant to all applicable provisions of section 1416.64, and a copy of that particular page was provided in the appeal. The applicant did request for and obtained a mandatory pre-application review of the request, which was included with the application, but no further review of the application and no recommendation was made to the ZHE.
I thought the recommendation was to proceed to hearing. Now, is it your argument that that is not the intent of that section that you cited? The intent is to make a recommendation of approval or denial, such as the planning department normally does with the EPC or the DRB?
Mr. Chavez, yes, that is our argument, is that, yes, the planning department does have the policy of having applicants go in and do a pre-review, just like they would do a pre-review for any case at the EPC to determine if it's sufficient for submittal. Once that submittal has occurred, those cases that have been submitted to the EPC are reviewed by staff, and then there's a recommendation to the EPC of either approval and denial based on what's been provided in the application itself. Based on the language in the IDO, it appears that that should also occur for ZHE cases.
I don't disagree with you, but tell me, assuming that you're correct, how would that affect the decision of the ZHE? I mean, I don't think I would remand it based on that alone, because assuming it's a technical violation, how does that affect the decision?
Well, so Mr. Chavez, in those instances, as being a planner myself for the city of Albuquerque, in my experience, if we felt that there were applications that were insufficient, that it was lacking any information, usually the staff person would reach out to the applicants and let them know your application is lacking this information. Or even prior to the hearing, when a recommendation has been set forth to the hearing officer, it's quite clear to the applicant as to what the recommendation would be. If the recommendation would be to deny the request because there were no specific policies referenced, it would give at least the applicant the opportunity to present that at the hearing itself and to correct the application.
It
So,
seems to me you're asking for something much different than what the IDO requires. You're asking for a courtesy call regarding whether or not you've fulfilled the requirements of the IDO. I don't think that is contemplated for the ZHE. I understand there's language that requires the planning staff to make a recommendation. It says they shall make a recommendation, but what exactly is that? What does that mean? I tend to agree it probably means that they should at least give some recommendation regarding the substance of the application rather than you can still proceed to application or to the ZHE. Because it seems to me that applicants have a right to proceed to a hearing regardless. And so it's kind of it's kind of perfunctory for a recommendation to proceed to hearing. But I'm just not convinced that the planning department is required to tell you you haven't met your burden before you've gone to the next step. But I'll look at that closer. So we can move on though.
well, and Mr. Chavez, I'm not saying that staff was required to tell me or even give a courtesy call to tell me. I know as a staff planner, when I was a staff planner, this EPC cases are not, they don't have as many cases as a ZHE. And so they don't have that sort of time at the ZHE level. I can understand that. But even providing a recommendation to the ZHE, outlining if there was a recommendation of denial, outlining what those deficiencies are, it would have at least given us an opportunity to address those at the hearing. So we were not expecting the city to come to us with a courtesy, but at least an awareness to the ZHE as to what was lacking in the application, if there was anything lacking.
Okay.
Okay, so in regards, we also believe that the zoning hearing examiner made a determination that is not supported by substantial evidence. The zoning hearing examiner approved findings of facts identifying information from the affected neighborhood association as substantial evidence that the conditional use would be inconsistent with the comprehensive plan. So specifically, finding number 17 identifies the evidence and arguments from the Santa Barbara Martinez Town Neighborhood Association as a substantial evidence that the conditional use would be inconsistent with the comprehensive plan. However, our appeal letter outlines how finding number 17 is not supported by evidence, and it was not substantiated. So generally, this finding accepts arguments that were made by the affected neighborhood association that indicates the subject site is located within a historical district, and this type of development should not occur because of its historical development. Arguments within the appeal letter specifically address how this area is not a historical district within the city of Albuquerque's IDO, and the neighborhood association has argued that the site will contain storage of materials that will have an environmental impact on the surrounding property. The applicant provided a list of materials to be stored on the site, all of which could be sold at a home improvement store, which is a permissive use in this zone category. The ZHE relied on a document that was provided by the affected neighborhood association, who presented the document as a study that shows negative impacts from neighboring businesses to the area. However, the document was not actually a study, and the report was completed in relation to a sector development plan that was adopted in 2012 and does not address the currently adopted IDO. The neighborhood association also made arguments in regards to traffic and impact to the immediate neighboring properties. However, the ZHE failed to recognize that a petition signed by abutting property owners was signed to show support of the request.
Ms. Garcia, look, I apologize. I need to interrupt you again, because if I don't interrupt you while you're talking, I will forget my questions as we get to the end. So my apologies.
No, you're fine.
That goes for both parties. But I saw the petition, But the petition isn't of property owners only, is it? It's property owners and tenants. And we don't know, unless you can tell me, who's a tenant and who's a property owner, because I saw that some of the residents that signed the petition are not listed as property owners on the official list of property owners. So I'm assuming that the distinction is that the petition people who are not on that list are tenants. Can you be more clear about that? And because it makes a difference whether they're tenants or property owners.
Okay. Well, we do know that there were immediate property owners who were notified of this request. We were required to give notice to the immediate property owners to give them, alert them to this request. So we did not hear any opposition from any of the individual property owners immediately surrounding this particular request. And in regards to the petition that was signed, Mr. Apodaca was able to secure the signatures on the petition and could speak to the tenants or the owners who live down in that area. Mr. Apodaca, can you address that question in particular?
Yeah, I can. Mr. Chavez.
Mr. Apodaca, hold on a second. Mr. Apodaca, hold on. Before we get to you, why don't you just make a note that that's a question? I want to finish with Ms. Garcia because she is subject to cross-examination, and then
Yes,
we
sir.
can get to you.
You got
Okay?
it.
Thank you.
You
so
got
much.
it.
So,
Mhm.
Ms.
Okay.
Garcia, why don't you just move on?
Okay, so furthermore, it was testified that the ZHE that there would be no additional traffic that is currently occurring on the site, and the applicant would like to say a few words in regards to the traffic within the area as well. So I would like to defer that portion of it to Mr. Apodaca as well.
Okay, before we get to Mr. Apodaca, I have questions for you when you've finished.
Okay,
So, are you
I'm
done
finished
now?
for now. Yes, yes.
Okay, so tell me what exists on the property today.
So, so right now there are two dwelling units, one of them, or two structures that were originally built as dwelling units. The one towards the front off of Broadway and Hannett in the corner was the one that's converted as an office. And then there's a back structure, the back dwelling unit was deemed as being dilapidated by the city. And so that's a structure that is substandard and the owner is wishing to demolish and rebuild or build a storage structure there.
So the primary building on the site is that house dwelling structure in the front on kind of the corner of Broadway and Hannett?
Correct. That's the main use of the building, which is, or the main use of the property, which is the office, and then the construction associated with the construction business.
So that's the construction business's base office, essentially.
Correct.
Okay. And then there's a building behind that that's going to be that's dilapidated, and you propose to tear it down and then replace it with a 3,000 square foot warehouse, essentially.
Yes, self-storage, yes.
Well, the site plan shows it as a warehouse.
Okay, yes, warehouse.
Okay, so it's going to basically house Mr. Apodaca's construction businesses, materials, supplies. I know there's a distinction with the party opponent regarding the definition of the term supplies versus materials, but whatever we call it, that building is going to house Mr. Apodaca's construction materials and supplies, correct?
Correct.
So the primary use of the property is for the construction business, which is housed in the front structure.
Yes, as an office, and then the storage, the warehousing for the materials.
Okay, so now tell me about the enforcement violations that had occurred. There was some talk or discussion in the record regarding enforcement violations on the property. What were those enforcement violations, and when did planning and zoning enforcement confront Mr. Apodaca with a notice or whatever?
I think I'd like to defer the specific dates or timeline with Mr. Apodaca. I want to make sure that that information is correctly conveyed, because that was not conveyed in detail as you're seeking now at the ZHE hearing. It was generally discussed.
Well, and can maybe you can answer this question. It appears, because I've seen a lot of stuff like this in the years, it appears that Mr. Apodaca was cited, or I'm only guessing, Mr. Apodaca was cited, or somebody had communicated with the city enforcement division that he can't store his construction materials and vehicles on the site, and that he needs to do something with that. And that's where the idea of a self-storage conditional use, that's when that came out. Is that correct?
Yes, Mr. Chavez, and you know, I can say that we did meet with code enforcement early on when we were approached by Mr. Apodaca to find out exactly what could be done to help resolve the matter. And so, you know, that's when we came up with the idea of putting in a self-storage unit for the materials. Now we understand that some of the other, the large equipment, the bigger vehicles that Mr. Apodaca uses from time to time cannot be stored there. And he is also has been reviewing other locations for the storage of those of that sort of equipment. And so but to resolve some of the matters that can be resolved within the site, we are seeking the conditional use for the self-storage. Mr. Apodaca lives right nearby, so it's convenient for him to live right by his business, and you know, with his office being there and the self-storage unit being there, for him to get materials to leave out of town, because as mentioned, he does have jobs throughout New Mexico, so he's not in town, does not typically run, you know, conduct the business there most of the time during the weeks, except for, you know, when he's there to pick up the materials and to do office work.
I'm looking at the site plan, and it's hard for me to read it. Essentially, it's a little small, simply because I don't have a larger copy. Do you have the site plan in front of you, Ms. Garcia?
Yes, I do.
Good. So when you look at the site plan, there's Broadway on the left side. When you're looking at it with the north going up, it looks like existing office. That's all I can read on that building, which is
yes.
What does it say?
Existing office to remain?
To remove?
To remain.
Remain. Okay, good. Okay, that takes care of that. And then there's 8 spaces. Those are parking spaces, I'm assuming.
Yes, that is correct.
And are those 8 spaces for the office?
So, Mr. Chavez, yes, those eight spaces, there are actually 9 spaces. One would be right next to the building itself.
I see.
But this is all based on what would be required if Mr. Apodaca is approved for the conditional use.
No, I understand that. I understand. I'm just trying to read the site plan so that I don't have to get you to supplement the record. So then right next to the parking spaces, to the right of the parking spaces, it looks like there's another structure that it looks like it's about 14 feet by 14 feet. I can't tell, but does it say office? Is it a second office?
No, Mr. Chavez, that's a garage that was built originally with the when the 2 dwelling units were.
Okay, I saw the photograph of the garage. Okay, so that's going to remain as well.
Correct.
Okay, and what's going to be in the garage?
I guess I'd have Mr. Apodaca.
We can get to him. Oh, good. Okay, so now moving back on the site plan all the way to the east side of the site plan, behind the proposed 3,000 square foot structure, there's two words that are kind of in the middle of the site that are diagonally. I can't read those two words.
Okay, so are you talking about east of the proposed structure?
Correct. Behind the structure, between the structure and the boundary line, there's two words that are in a diagonal format.
Okay,
In the middle.
so, yes, so Mr. Chavez, that says demo residence.
Demo residence. Okay, so
yes.
that's where the residence is. Okay,
Correct.
I see it. So the structure is basically an overlay over the residence in the
Correct.
site plan. Got it. Okay. Now on the north end of the building, there are some words with an arrow. It looks like, I'm guessing it's a fence that language is describing, but can you tell me what the description is?
So that reads a 5-foot front setback required. And then it indicates that a 7-foot setback is actually provided.
Got it. Okay. And then on the other side, which is the south side, there's similar language. What does that say?
It says 5 front setback required and provided. So there is a 5-foot setback required on that side.
Okay. Now describe, tell me what the language says for each, for the structure. There's 3 separate categories, it looks like, 3 separate lines or arrows, beginning with the one to the north, the first one to the north. Do you see that?
Yes, so that reads exterior door to hallway.
Okay.
So that would be a pedestrian door.
Okay.
And then below that says the interior hallway to access units. So
Okay.
what is showing within the structure itself is you see 3 separate areas for storage that are divided by a partition with a hallway that connects to each of the units, to each of those.
I assume you have 3 separate areas divided by a partition, by 2 partitions, based on the definition of a self-storage in the IDO.
That's correct.
Okay. What does the third one say?
The third one says an exterior overhead door.
Okay. And in the second section of the storage facility, there's some words inside the building. What does it say?
So that also reads exterior door to hallway. So that's another pedestrian door.
I see. Okay. So, okay. I just needed to read all that. Good. Okay. Thank you so much. Do you have anything else to add to your testimony?
No, I do not, other than Mr. Apodaca's,
We'll
and
get-
it's
We'll
quite
get to Mr.
possible.
Apodaca. You're subject to cross-examination next before we get to Mr. Apodaca. Ms. Naranjo Lopez, do you have questions for Ms. Garcia? Only questions, not rebuttal argument, but you have a right to cross-examine Ms. Garcia. That is, you can ask her questions regarding the testimony that she has just given. Would you like to do that now?
Mr. Chavez, I just wanted to make a statement.
No, not yet. Not yet. No
Not
statements yet. I will let you have that time, but this is just for
Oh.
cross-examination. Do you have any questions of Ms. Garcia?
No, I don't have any questions.
Okay, good. Okay, Mr. Apodaca, and you're already sworn in. Let's hear it from you, sir. Mr. Apodaca?
Okay, I apologize. I'm not all that technologically inclined, so I'm trying to get in. Yes, go right ahead.
Okay, so go ahead and testify. If you have anything to say.
Yeah. So in regards to the traffic, we do in the surrounding area and nearby that does come through the Hannett side, which I do live there. I am a resident. we do have the Olivas Trucking Company that comes through this area all the time. We also have the subcontractor for the post office that is coming through here all the time. We do have the Ashcraft contractors that are through this area that come here through all the time. And of course, the city to maintain the parks, UPS, FedEx. So there's a lot of big trucks, and traffic that does come through this area. We do not traffic this area.
Mr.
Yes.
Let me stop you there. This isn't the opportunity to describe all those things. This is an appeal hearing, and I know you're not a lawyer, and so I want to be very careful. This hearing is to determine whether or not the ZHE basically did something wrong, whether or not he erred in his decision in some way. And
okay, so yeah.
Hold on, let me finish. So I don't really, I know there's a lot of evidence in the record regarding traffic. I understand that, I've read that, and I know what the traffic condition is based on the evidence in the record. So if you could just, if there's anything you would like to add to the record regarding the appeal issues, that's what I really care about.
Okay, I guess at this moment I don't have anything.
Okay, yeah, and my earlier question regarding I guess whether or not there's tenants or owners.
They are all property owners.
So the people on the petition are all property owners?
That is correct. That is correct.
There are no tenants on that petition?
There may be one. There may be one tenant, and if you would like, we can remove that tenant off the record. But the rest of them are landowners here. They do own these properties here.
Which one is a tenant that you know of? If you don't know, it's okay if you don't know.
She is the one that lives next door to 412 Hannett.
Okay, next door to 412 Hannett. And which one is that?
412 Hannett is my residence.
I see. Okay, so next door. I don't know where 412 is, so I haven't. I need to go back and look at that issue. Are you saying it's in between you and the subject property, or on the other side?
It's next door.
Okay, that's what I thought. Okay, good. So now regarding your the code enforcement issues that were brought up in the record, when were you notified by the City Code Enforcement Division that you are in violation?
I believe that was in December or either November, December, if I'm not. I don't have that in front of me, but it was in that time.
Late last year,
yes,
2019. Okay, and
yes, that is correct.
What were the violations? Alleged violations.
So, I think the violation was it was being used as a contractor's yard.
I get it. Okay, so you're basically storing your contractor vehicles and equipment at that location.
That is correct.
I get it. Okay, good. Thank you. I don't have any more questions. Do you have any more testimony?
No.
Ms. Naranjo Lopez, do you have any questions for Mr. Apodaca regarding his testimony?
No, I just would like to make a statement.
And you will have that time. I apologize. This process, I know it's a little tedious, but it's the process that I have to follow. Okay?
No problem.
Thank you, Mr. Apodaca. Ms. Naranjo Lopez, it's your turn now.
Okay, good morning, Mr. Chavez. Thank you for allowing me to speak. The Santa Barbara Martinez Town Neighborhood Association asks that you uphold the decision of the zoning hearing examiner. Our main concern is a precedent. This request will have set in the historical residential neighborhood. I submitted a letter to you.
I have that letter and it's in the record.
Okay, so we would like you to consider that letter and the whole record as part of your decision. That's already from the zoning hearing examiner that we also submitted a letter at that time. And I just wanted to state that the violations continue, so they haven't stopped. The violations continue. And we would just like you to consider the zoning hearing examiner's decision. So thank you.
Are you finished, Ms. Lopez? Naranjo
Yes,
Lopez?
I'm finished.
I have a question for you.
Okay.
You mentioned in your letter and in the record, essentially, to the ZHE, that there's a lawsuit, there's litigation regarding this property in I think it was 240 something Broadway Northeast. There are two properties essentially that there was litigation over the zoning, which includes this subject property. Is that true?
There's not a litigation specifically on a certain property. I think you're referring to that one of the properties continues to violate the
Okay,
current
so I
zoning code.
misunderstood that.
But we are in litigation with the city of Albuquerque due to the commercial zoning on historical residential property.
The
And the
MXM,
discrimination.
I'm sorry, the MXM zoning on
The whole IDO, we're going to court on it in
Okay.
regards to discrimination and racial inequities in the neighborhood.
Okay, so when did you file the lawsuit?
Oh, wow. Right at the IDO was, I think, effective.
2017.
Yeah, May of and we had like so many days to file it. So we filed it within that time period.
Okay, so it wasn't after one of the amendments, it was when the IDO was adopted.
When it was officially effective, yes.
Okay, and I'm interested
That
in
exact date.
I'm interested in this litigation. I mean, I'm not sure how relevant it is. It could be relevant. It may not be relevant to this application. Are you represented? Is the association represented by counsel, by attorneys?
Yes, by Cuddy and McCarthy.
Okay. Has the court issued any stays on any zone changes or any other changes?
No, we're
that would affect
looking at
zoning?
going into mediation at this time, which is required.
Okay. Okay. So to the best of your knowledge, there are no stays. And do you know what a stay is? That basically like an injunction where the court says, the city of Albuquerque, you cannot do anything with zoning until
There's
I've
none
resolved.
at this
Okay.
time, no.
Good. Okay, good. Well, that takes care of that issue then. Is there anything else, Ms. Naranjo Lopez?
No, that's it.
Thank you.
Thank you for the time.
You bet. Ms. Garcia, you have a right to cross-examine Ms. Lopez. Do you have any
Okay,
questions?
I do. I just want to know if Ms. Naranjo Lopez or the neighborhood association, if they're aware of the site zone category and that it's a commercial zone category.
I'm not going to let you ask that question. I think it's not relevant. I mean, whether they know about it or not is irrelevant. It is what it is. I know about it, and I'm sure the ZHE did when he made his decision. So I don't think that's an appropriate question. Do you have any other questions, Ms. Garcia?
What about the historical status of the property that is referenced numerous times by the neighborhood association?
I think the issue is that they believe it has historical significance, and at one time it may have had historical zoning, but now it doesn't have that. And I think we all have agreed, and I mean, I can't find otherwise. There's no historical zoning on this site. Isn't that correct, Ms. Garcia?
Well, yes, I agree with that. I'm just wondering if Ms. Naranjo Lopez has a different understanding and whether or not there's something she can point to identify it as historical.
Okay.
Within the IDO.
So there's no,
Go ahead.
I guess I'd like to just clarify. that we are a historical neighborhood. That's no question about it. We submitted our memorial that was done at the legislative session. But we've never mentioned on the record about a historical overlay or the state registry where you get a historic registry from the state. We have specific buildings that do have recognition and are registered with the state for those specific buildings, like Santa Barbara School, the Second Presbyterian Church, San Ignacio. There's an old farmhouse at the corner of Odilia and Edith that are also recognized by the state. But in our record, you'll see that we never mentioned that we were under the state recognition. We just say we're historical. And I mean, anybody would tell you we were, and we also are members of the Historic Neighborhood Alliance, which is South Broadway, Varela, San Jose, and we all consider ourselves historical.
Thank you, Ms. Lopez. Ms. Garcia, any more questions?
No, no more questions.
Mr. Apodaca, do you want to ask questions of Ms. Naranjo Lopez?
No.
Thank you so much. Any rebuttal? Any final closing remarks, Ms. Garcia? You have technically you have some time for that.
Okay, Mr. Chavez, we just want to ask that, say in conclusion, the denial of this conditional use is contrary. We believe it's contrary to the IDO as discussed, as mentioned. And the associated notification of decision letter contains findings of facts that are not supported by the record. We request the approval of the conditional use or have the matter remanded back to the ZHE for a re-examination of the application if you are unable to review the entire application. In our minds, it appears as if the zoning hearing examiner just reviewed just the first criteria and just stopped there and did not continue with the remaining portion of the application. And so if you find that to be true as well, we would ask that it be remanded back to the ZHE for reconsideration. If you believe that you have the authority to review the entire record and make a determination based on what's been provided, then we would recommend that as well.
Thank you. And I do have that authority, and I will. I mean, I don't necessarily agree with many of the ZHE's findings. I do think they are not supported by the record. However, my concern is very different than how the ZHE looked at this. My concern is that you're using a primary use to achieve a different use. That's my concern, and I'm going to look at that very closely. I think the testimony bears that out, but I'll look at that closer. I'm concerned that you're using self-storage and you're making this structure look like a self-storage facility, but that's not the primary use. And the primary use is a construction company, and that use is not permissible in the zoning code, in the IDO, in this zone. And so that's my concern. And I'll look at that very closely. Thank you, folks. We will go off the record.
Thank you.
Thank you again. Bye-bye. Enjoy your days.
Thank you. Bye.
Thank you.